Godwin Emefiele's issues with the Department of State Services go back, in recent times at least, to December 2022. That was when the DSS came out in the open to accuse the suspended CBN governor of terrorism financing and economic crimes. However, at that time, a federal high court sitting in Abuja declined the DSS application to arrest and detain him. And just days after that, a high court in Maitama issued an order restraining the DSS from arresting Emefiele after the Incorporated Trustees of Forum for Accountability and Good Leadership filed a suit asking the court to restrain security operatives, that is, the DSS and the EFCC, from arresting Emefiele. Now, both judgments said that the DSS had not provided concrete evidence to substantiate claims against him. The FCC did clarify that it had no case against Emefiele, and neither was he under investigation by the commission. Now we fast forward to June 10, 2023, when news broke that Godwin Emefiele had been suspended from his role as the CBN governor and had then been detained by the DSS. The department initially denied that he was in their custody until a few hours later, when it confirmed that it had in fact arrested him. Emefiele has been in DSS custody since June 10th. And he has now filed a fundamental human rights suit against the DSS, alleging that he is being unlawfully detained. Joining me now to look deeper into this is Alesta Wilcox, political analyst, and also with me, I have legal practitioner Alfred Ayova joining me tonight for this conversation. Gentlemen, welcome to Politics HQ.
Thank you very much for having me. It's my pleasure.
So I think it's prominent or very important for us to start with a trip down memory lane, and particularly around this conversation. There have been calls for Emefiele's arrest and calls also saying that he's the victim of political maneuvering and harassment from the DSS, even before he was eventually arrested and detained. When we look at the timeline of the things that have happened between the DSS and the suspended CBN governor, Alfred, I'll start with you. Do you think that the DSS has behaved appropriately and within the legal mandates that the service has?
Yeah, as a security agency and as law enforcement agencies of the Federal Republic of Nigeria, I cannot preempt that they do not have the mandate. They do have the mandate if they feel from intelligence they've gathered that yes, they have to go against someone. I can say they acted within their mandate.
So what do you think of the appropriateness of their actions stemming from some of the things that happened in December 2022 up till now, when he is finally now in their custody?
Yeah, now when we look back at what happened, an order of the High Court restraining the DSS from arresting him and the Federal High Court. Now the fact that when commission of a crime is an issue, the circumstances differ. If today you come against me, and the court say, no, you cannot arrest Alfred for today because he has not committed an offense, it won't be the same circumstances that will arise as of tomorrow. If tomorrow I wake up and I decide to commit an offense and the situation change or the circumstances change, definitely the law enforcement agencies can come against me despite the law, despite the order restraining them, because the circumstances must have changed. So probably as of the time the DSS wanted to arrest Emefiele and he went to court that his freedom or fundamental right has been threatened, and the court ordered the restraining order, probably in June 2023, when they went after him, they must have presented facts or said something that the circumstances have altered, which will allow them to arrest him. The legal implication of him staying there is all over another thing in talk. But if the circumstances change from what they intended to do before the court restrained them, and then after the restraining order, if circumstances change, they can do that. They are within the law.
Okay. So, Alesta, I'd like to get your thoughts on this as well, as sort of an opening point of the conversation. We've seen the issues, or at least the engagements, we can call it that, between the DSS and the now suspended CBN governor. We can leave the legality aside, but when we look at it in terms of the appropriateness or in the manner in which the DSS has acted towards him in recent times, what do you make of it?
Well, the DSS and Emefiele Buhaha didn't start today. It's been on since June last year. That even made him flee the country, and people say his associate he was on leave, and he was out of the country for a while, only to come back towards the twilight of the last administration. So he's been on the radar of the DSS for a while now. It's not a recent development. So as such, the DSS and Emefiele, so nobody can link to the fact that Emefiele is being witch hunted. If it was being witch hunted, then the last administration will have returned into, because remember, he was protected by last administration. So the DSS itself has acted as an independent body, even in the last administration that he served and served very well. So I am not oblivious of the fact that I don't have any doubt in my mind that the DSS has a valid case, and nobody's above the law, be it the CBN governor, be it anybody. So long as you're not covered by immunity, nobody's above the law. So if he has been having issues, a running battle with the DSS before now, and then the CSS were able to lay hold on him now that he was suspended from office, I think everybody should keep quiet. I mean, should just calm down and allow the due process of law to take its place, because we're talking of national security at this point. What is at stake is national security and not anybody's interest, because the DSS, the allegations levied against Emefiele borders on national security. We are talking about financing of terrorism. So these are serious issues, and it didn't start with President Bola Ahmed Tinubu's administration. It has started even before the administration came to power, and we know it. He has run away from the country. He's been protected by some powers, and he ran out of the country only to be brought back with assurance that he was not going to be arrested. So let us just give the states the benefit of doubt so that they can conduct their full investigation and see how they can take it from there. It's our national security, not anybody.
Okay, so we'll come further to the charges against Emefiele in just a moment. But Alfred, let me come back to you. So now he is in DSS custody, and through his lawyer, he has filed a fundamental rights enforcement suit alleging that he has been denied access to his family and his lawyers. Now, the DSS has denied this, and we've even heard from Dr. Peter Afunaya in I guess we'd say an op-ed, or at least an article that he read in a way defending the DSS. Alfred, in such a suit, what would Emefiele need to prove to possibly even win in court in terms of saying that the DSS has denied him his human rights?
Okay, this issue, I may not go into depth on discussing this very matter, since the matter is pending before the court, so that my analysis do not prejudge or predetermine the outcome of any decision the court may pass. But suffice to say that for anybody that has been accused of any offense, the Constitution presumes you to be innocent. So as it is, even though he has been accused of financing terrorism, we presume him to be innocent. But then there are some constitutional guides that respect the fundamental rights of individuals, no matter what offense you have been charged of or you have been arrested or suspected of. Financial terrorism is amongst them. You are entitled to your fundamental right to liberty, freedom of expression, and these fundamental rights at that moment, they have some limitations that you cannot enjoy them at full force. So Mr. Emefiele has been in custody. He alleged that he has been denied access to his lawyer and right to fundamental right to personal liberty. Now, at the moment, his fundamental right to personal liberty is not absolute. And if you look at what the DSS and the Office of the Attorney General of the Federation are saying, that his detention is valid because after he was arrested and kept in our custody, they proceeded to a magistrate court in line with Section 293 of the Administration of Criminal Justice Act 2015, obtained an order from the magistrate to keep him in custody pending the outcome of their investigation. And if that order subsists, it means they are still within the confines of the law. They are not detaining him at will, but based on the court order. And the funny thing is that the Administration of Criminal Justice Act Section 293 provides that the order should be made ex parte. So him, Emefiele, nor his lawyer may not even be privy to the processes that led to obtaining of this order ex parte. And that is a defense they are coming up with. And if that is true, then their defense is absolute. They will get away with it. It happens a lot of criminal issues, criminal trials that we handle in court. Most times, some magistrate will be fought, they may be bold enough to come and tell the DSS or the police, as the case may be, that no, you cannot keep the person. But once they make the order remains valid and is binding. If you want to challenge it, it's by way of an appeal, but the order remains valid. And that is a defense. On the part of Emefiele, yes, he has been detained beyond the constitutional period. But just like I said, the limitation is there, which is an order of court that the DSS are relying on. So if they rely on that order, I think they will get away with it.
Okay, so that puts a bit of more context in terms of this fundamental rights enforcement suit that he has, of course, put in place. But that has now been postponed, I believe, to July. But when we go further into the allegations, as I told Alistair we'll do, I want us to really look into what the allegations are. They're not yet charges, but these are the allegations against him. And they came because the DSS and the Office of the Attorney General of the Federation were responding to the fundamental human rights suits. Now, the DSS said that Emefiele was being held pursuant to an order of a competent court, adding that the suspended CBN boss was arrested, and I quote now, upon reasonable suspicion of committing acts which constitute a criminal breach of trust, incitement to violence, criminal misappropriation of public funds, economic sabotage, economic crimes of national security dimension, and undermining the security of the Federal Republic of Nigeria. Now, in its own affidavit, the Office of the Attorney General of the Federation dismissed the speculation that he was being held for terrorist-related crimes, also saying that he's not being victimized for his involvement in politics and the controversial Naira redesign policy. Alistair, you have started talking about the allegations against Emefiele, so let's come back to you on this. This moves us away from what the DSS was alleging when it was December 2022. Now, with the weight of these allegations, what do you make of them?
Well, like I said, the cat and mouse game between Emefiele and DSS has been on the road, and for him to have fled the country before now means these allegations are weighty, and there is no smoke without a fire. Well, like you said, the allegations they've not been turned into a proper charge that will be presented before a court. I'm sure the lawyer will be able to educate us on this. But to the ordinary Nigerian, Emefiele has become a divisive figure, especially based on the fact that he frayed into the murky waters of politics, and then the much controversial renomination and redesign policy, which put him at loggerhead with a lot of politics and a lot of Nigerians. So he's passing through trial now, or through the process of the DSS. It's not dividing the populace. A lot of people see it as victimization. And of course, like I say, his case with the DSS didn't start today. Remember, he has been protected by a lot of people. And until Emefiele is being subjected through the rigors of judicial processes, Nigerians will not get to know the extent to which a lot of atrocities were committed in this country. Emefiele was being protected by a lot of people, even up to the former Attorney General of Nigeria, protected Emefiele. A lot of insiders in Aso Rock protected Emefiele. When these allegations were brought up, remember in fact, these allegations did not emanate today, so they were not crimes not committed in recent times, as in during the administration of President Bola Ahmed Tinubu. So these allegations has been there even during the past government, and it was protected by people. I want to salute the DSS at this point, because the DSS before the advent of this administration, even though the president was the one that appointed the DSS director and report to him, they seems to do their work independently of the powers that be. And that was why they were able to go for an Emefiele. And Emefiele was being protected by some other powers within the same government, up to the Attorney General, the former Attorney General, Malami. They were all involved in protecting Emefiele. So it shows that Emefiele's crime is real. So there is no victimization, no political vendetta. His crimes are real because it didn't emanate today. And so Nigerians, my appeal is that Nigerians should allow this process to go through, because a lot of things happened in the last administration. Remember, we are fighting terrorism, and it was not ending. We are fighting kidnapping. It was not ending. We are fighting killing. A lot of our servicemen and women have lost their life through in the fight against kidnappers, against bandits, fight against Boko Haram, fight against all kinds of insurgents, and it was not abating. And now the DSS is giving a clue to the fact that somebody, somewhere, we are financing some of these things. So Nigerians should be happy and should be delighted to know the truth as to why and what we faced in the last 10 years of Nigeria, of our lives. Because the former government inherited the problem and it didn't abate throughout the tenure of this government, even though it diminishes sometimes, it comes up. So, and the allegations against Emefiele revolves around some of these things. So I think it is a good beginning. It's a good start for Nigerians. Let us even know. And why were some people protecting Emefiele? What was he being protected when he fled the country and he came back with an assurance that he was not going to be arrested and all that? Why was he being protected? So as far as I'm concerned, Emefiele's crimes seems to be real. The DSS have a good case against him. And it is not a time to talk about human rights or fundamental human rights. Look, if you have your rights, yes, nobody says you don't have your rights. Then I'll subject it to the whims and caprices of the legal system and get yourself innocent, prove innocent, because it's only Nigeria we hear these cases of presuming innocent until otherwise. Other parts of the world, when you are suspected, you are brought before the criminal justice and your rights are restricted, because some of the things that you are supposed you are accused of borders on the rights of other people. Just as you have your own right, others have their own right too. If you are accused of economic crime, your actions have caused undue pressure on some other people. If you are accused of terrorism, your actions have caused a lot of discomfort to other people. So you will still have post right, and you cannot come and claim your right when you have not passed yourself through the so pass that through the process and come out clean, and then you go home. But don't say that as soon as you are arrested, you're talking about rights. I don't buy such ideas, because we are talking about a country where everybody is involved.
All right. So, Alfred, again, coming back to you in terms of a legal standpoint on this, and while we know the matter is in courts, there's only so much you'll be able to sort of presuppose, but how easy or difficult would it be, do you think, to prove some of these allegations in court? What is the type of evidence we should be expecting, or you would expect to see presented against Emefiele in terms of meeting the burden of proof and being able to meet the weight of the allegations? Again, just for emphasis, we're talking about incitement of violence, criminal misappropriation of public funds, economic sabotage, economic crimes of national security dimension, and even undermining the security of the Federal Republic of Nigeria. Again, weighty allegations. How does one go about sort of proving these type of allegations in court?
All right. In criminal trials, generally, the proof is required to be beyond reasonable doubt. That is, you need to put the proof and the concrete evidence to establish the offense for which any defendant is being charged. Let's take criminal misappropriation of funds, for instance. If you are alleging that someone has committed criminal misappropriation of funds, it means funds were actually appropriated for a particular purpose, and the person utilized the funds for the purpose other than which it was actually approved. So if you are able to prove that these funds were meant to be used here, but then they were used there, that's the evidence as is required. It has to be beyond reasonable doubt. It can't be mere speculation or conjecture. And then the burden will now shift to the defendant, that's Mr. Emefiele in this case, to establish that no, this is not what happened. He has several defenses that are meant for him. This is what the money was approved for, and this is what it's meant for. You are talking about economic sabotage. What did he do that sabotaged the economy of the Federation? What was the economic plan of the Federation, and what was the action of Mr. Emefiele that sabotaged the economy? So you need to have concrete evidence in criminal trial. Most times we see these kind of allegations that are branded in the media, but when it comes to bringing out concrete evidence to establish the guilt of the person, we don't see the evidence there. We're talking about terrorism financing. If you're talking about terrorism financing, it means Mr. Emefiele used funds that were maybe meant for the central bank or Nigeria at large to finance terrorists. Now, you have to bring, there are terrorists that were financed, monies were put into them. You have to bring those evidence. Okay, maybe this is a terrorist group, A and B in Zamfara, in Benue, in this place. He financed these groups. So you have to bring those evidence. It's not a mere suspicion that monies were expended. There should be a link with a terrorist group that were financed. So a lot of these allegations, when it comes to bringing evidence to prove them, it's always hard. But I hope the DSS they have the capacity, they have all it takes to establish these facts. For them to have arrested him, it means they had information and they can investigate to establish this information. But I can tell you as a matter of fact, the allegations they are branding, the evidence they will need to prove this allegation are hard, concrete evidence to nail him. And then he has also his defense to make. Several defenses that are available to him. If he has done what he was meant, if he has done what the funds were meant to, then he cannot be culpable. Again, most of these allegations, they may involve third parties. And that's where the trouble comes most time. Maybe the money was sent to A and B. A did not utilize the money was sent to C and D. C did not utilize the money. C was meant to handle the economy. C failed to do what he or she was meant to do. And if it involves you bringing these people on board, it may not be Mr. Emefiele alone. You will say he conspired. I mean, there must be someone else he conspired with. You will say he misappropriated funds. Maybe you will say, I'm only the governor. I'm not in charge of this. This is the person in charge of this. I gave the directive and this person did not do. You have to bring the people as well. You see that the chain will get long. And I think that's where most of the security agencies will somehow lose investigation because they may not be able to extend their investigation to who and who they are supposed to bring to establish their cases. And then they have gaps. And once there is a little gap in criminal matter, just a slide, you see that the person goes scot-free because there is this saying that it's better to set one innocent person than to convict 10 guilty people. So they need hard, concrete evidence.
So as I said earlier, these are still the allegations. We still don't know what eventually Godwin Emefiele will be charged with and, of course, how long this case will take. But, gentlemen, let's hold on because after this break, we want to look at the consideration of Emefiele as a flight risk if he is granted bail and also how the DSS has been responding to criticism of its actions. The spokesperson actually wrote an article about this. We'll get into that after this. This is Politics HQ. As the Department of State Services and the Office of the Attorney General of the Federation responded to Godwin Emefiele's fundamental human rights suits in court, they both have asked the judge to dismiss the suit and allege that Emefiele would be a flight risk if he is granted bail. My guests are still with me, Alesta Wilcox, political analyst, and legal practitioner Alfred Ayova. Now, gentlemen, as we continue to look at this, let's look at this consideration of Emefiele as a flight risk if he is granted bail. The unfortunate circumstance is that Nigeria is no stranger to having high-profile individuals who are facing charges in courts or already in the trial stage, fleeing the country, fleeing past immigration and oftentimes the security services that are meant to keep them in the country to face these trials. So, Alessa, I'll come back to you now. In terms of, okay, we've lost Alessa, unfortunately. Let me go to Alfred. When we look at the allegations, which we just finished with right before the break, and you look at the weight of these allegations, when you look at the consideration for bail, consideration for Emefiele to be considered a flight risk, what do you make of that?
Now, when you hear issues of someone is a flight risk, most times you begin to look at it. The first issue is what is flight risk? By judicial interpretation, flight risk means if this person is granted bail, he will not make himself available. He may flee away. That's just it. What is the main reason why bail is granted? Bail is granted so that anybody that is accused or suspected of having committed an offense will come and attend to trial. That's the main essence of bail. So if you say that you will come to court, attend to trial, then bail should be granted to such a person because from the allegations we have seen so far, most of them are bailable. But let's look at the issue of flight risk. Now, right from investigation, probably the DSS must have extended invitation to Mr. Emefiele for several times and he did not honor that invitation. Now, when you start ignoring law enforcement agencies, you are a flight risk. You were sent invitation, you did not attend. You have to arrest you. They trade you, made effort and arrested you. Definitely, it means if you are given the opportunity, you will not attend court. You will not make yourself available for trial. So it becomes an issue. If he had willingly submitted himself before the DSS, he can argue, yes, I came willingly. You did not compel me to come here. But the DSS has to throw him, arrested him, flew him from Lagos to Abuja. So they have a point they are making there. And looking at the allegations, there are several allegations that are leveled against him. And they are high-profile allegations. Terrorism is one of the things that we're facing at the moment. And if I accuse of having been a financer of terrorists, definitely that's a high-profile allegation that a lot of people, even the court, will be skeptical of giving you bail. But let's look at it on another angle. Once you arrest somebody, even in culpable homicide offenses that are punishable with death, the person is entitled to bail, provided the person can present himself for trial. So most times when law enforcement agencies brandish this issue of flight risk, you have all the mechanisms that are needed to prevent the person from going out of the country. So let's take, for instance, the DSS, they seize his international passport, restrict him to Abuja, or do all sorts of things. But keeping him in custody will not be a solution to it. But making sure that he attends trial, should be the paramount reason why bail should be granted. It's a public figure. Yes, of course, I cannot say. I don't know the evidence or information that they have before they are saying he's a flight risk. But from the look of things and from what I can say, most of the offenses are bailable, although terrorism is also a bailable offense. It can be bailed for me, even culpable homicide offenses. So I don't think he cannot be granted bail because the offenses are weighed. I think he can be granted bail, but then on stringent conditions that will not allow him jump bail and then frustrate all the effort the DSS are making. We are not saying he's even guilty of the offenses, but let him attend trial, attend to the DSS, defend yourself from the allegations that have been leveled against you. Then if you are clear, you go scot-free, but you have gone against the law, then the course of the law will take its course.
All right, Alfred, just for clarity, the DSS has not said that Emefiele is actually facing terrorism charges. Let me reiterate again what the DSS said in response in court yesterday. Upon reasonable suspicion of committing acts which constitutes a criminal breach of trust, incitement of violence, criminal misappropriation of public funds, economic sabotage, economic crimes of national security dimension, and undermining the security of the Federal Republic of Nigeria. And as well, the Office of the Attorney General of the Federation has also dismissed the speculation that he's being held for terrorist-related crimes. So as of right now, terrorism financing, which was something we heard in relation to Emefiele last year, is not on the table in this circumstance. But I want us to go to jurisdiction, and it comes up often when we have cases like this. So Tijani Ghazal, SAN, who's representing the Office of the Attorney General of the Federation, told the court that the suspended CBN governor was being detained on the order of an FCT Chief Magistrate's Court. He also told the courts that the OAGF, which is listed as the first respondent, was challenging the jurisdiction of the court to hear the case, given that Emefiele's arrest and detention were administrative decisions of an arm of the executive arm of government, and that a court's jurisdiction is determined by the relief sought by an applicant. For many people, this might sound like a lot of legal jargon. So, Alfred, help us break it down. Does Ghazal seem to have a right direction? Is he heading in the right way when it comes to the issues around possible jurisdiction of the court that's hearing the fundamental human rights case?
Yes, the High Court of the Federal Capital Territory, the Federal High Court in any division has a jurisdiction to hear fundamental right cases as provided by the Constitution. But the issue here is the Office of the Attorney General is arguing that Mr. Emefiele is being detained by an order of a magistrate court, which means if you want Mr. Emefiele released or you claim that he has been illegally detained, it means the order has to be vacated. The Constitution did not give jurisdiction of fundamental enforcement proceedings to the magistrate court, but this is what happened. I explained earlier in this on this program that most of the times the law enforcement agencies or Office of the Attorney General of the Federation, they approach a magistrate court with a motion ex parte. So Mr. Emefiele may not actually be aware that the motion ex parte was filed and granted against him. His lawyers will not be aware. They get these orders and keep them. So when an issue like this arises, they will bring out the order, we obtain an order, so we are detaining you based on a valid order of the court. But Mr. Emefiele's lawyers are right. They can't approach the magistrate court for enforcement of fundamental rights. They allege that the fundamental rights of their client have been breached. So the proper forum is the FCT High Court or Federal High Court. So they are the proper forum. But the issue now is he has been detained by an order of court. So it's not as if they will go back to the magistrate court to ask that the right of Mr. Emefiele be enforced. No, they are the proper forum, Federal High Court or the FCT. So if they want, they can argue to set aside the order or whatever the court can make of the order. It depends on the judge that will make the order. It depends on the judge that is hearing the matter. So like I said, I don't want to delve into the legality or otherwise of that order. I don't want to go into it since it's an issue that is before a court. Okay. But I can tell you that they are the proper forum, FCT High Court.
At the proper forum. I want us to come back to the DSS because it seems to be responding a lot to criticisms that have been leveled against it. So in an article written by Peter Afunaya, the DSS spokesperson, he pointed out that recent media editorials which sought the reforms of the DSS or have even criticized the agency for its statements and actions in recent times on national concern are interesting. He said, and I quote, "It looked every inch planted or organized. It is a hatchet job, or so it seemed. The judgment that the service is excessively public or ubiquitous missed the point. The papers are manifested predictable bias and patterns, end quote. He also said in that article that it was a warped mentality that produced the write-ups that seemingly seemed to be criticizing, of course, the actions of the DSS. So now there seems to be this belief that any criticism of the service is either not sincere or genuine or comes from a very misinformed place. Is this the sort of defense we should be seeing from the DSS in terms of hearing what the criticisms of its actions, its behaviors, its mandates might even be? Alfred, what do you think?
I think the DSS will even appreciate the citizens for scrutinizing their action, because it will help them perform better in the eyes of the citizen, and then even put them in a better picture to the international community. Yes, they have to enforce the law, but as they are enforcing the law, there are procedures and rules of engagement that they have to obey. So the DSS, they shouldn't be angry that people are criticizing them. They should be very happy. As a television station, if people criticize you, you should take correction and then you improve. So I think the spokesperson coming out to say the citizens are criticizing them unjust, I think is not correct. The citizens have the right to scrutinize their activities and criticize where possible, and then probably offer solutions to them so that they can improve and be a better security outfit. And I can say that most of the security agencies in Nigeria, when they are carrying out activities, most times they go overboard. That's the truth. They forget the rules of engagement, like they're engaging with a civilian to uphold the fundamental right of the person to, even in their custody. Most times they don't obey these rules. Like, let's take for instance, if when Mr. Emefiele was in custody, I learned from what we read in the media that he was not allowed access to his lawyer. Probably when this issue was brewing before they went to court, if only they have responded to the lawyers, maybe in writing, that okay, Mr. Emefiele is not in our detention by our own doing, but by an order of court. Probably the lawyer would have sufficient information, or Mr. Emefiele would have informed his lawyer, probably, and then they will know the step to follow. But you see, they are being confronted with the order the DSS obtained in court. They were not aware. I can tell you as a fact, because the law provider should be made ex parte, and it happens most often. So they should not get angry or distracted that people are criticizing them. They are pointing out the wrong things they've done, so they should take correction. I think it's not unjust.
Lester Wilcox is back on the phone line with us, joining us via phone now. Lester, I was asking Alfred about what seems to be the response of the DSS, given that Dr. Peter Afunaya had written an article which spoke about the mandates of the DSS and that the DSS was well within its mandates. He had a lot to say about the criticisms, said that it was a warped mentality that produced it, that of course they are planted and it seems to be a hatchet job. Earlier, you were applauding the DSS for some of their actions, particularly in regards to Emefiele during the time of former President Muhammadu Buhari. But now looking at this response, what do you think of it? Is it back sort of, tightening down the hatches and saying, no, we believe we're in the right and your criticisms fall by the way? Or as Alfred said, do they really need to pay attention to what Nigerians and people like Femi Falana and Olisa Agbakoba are saying in terms of how they're handling things in recent times? Hello, Alesta. All right, we seem to have lost the connection to Alesta, but if he's able to join us before we wrap up the show, I'll put that question back to him. Alfred, I still have some questions, particularly when it comes to constitutionality. And there are a number of things that Dr. Afunaya said in that particular article he wrote. So let's talk about that right now, because he also wrote about the conversations around the constitutionality of the DSS as an intelligence organization in detecting, preventing, and even neutralizing threats against Nigeria. He stressed that the service is not only an intelligence organization, but also a law enforcement agency, a security and policy advisory organ with its establishment law expecting it to prevent crime. So when you look at the defense mechanism or the defense that it seems the DSS has put up, and coming back to a conversation around its constitutionality, because that seems to be a sore point for many people when it comes to issues around the DSS. When we look at it as a law enforcement, security, policy advisory, and even preventive agency, when it comes to its mandate, should we be looking at reforming the DSS?
Sorry, I didn't get the last thing you said.
I said, should we look at reforming the DSS?
Okay. I think DSS as an organization, they have a lot to offer to the nation in terms of security. And from understanding of their security architecture, they are an organization, they are well organized and they work very well. But the problem we have in Nigeria, not only from the DSS, but other security agencies, they forget that as far you have a mandate, a constitutional mandate, you have the rules of engagement, but the citizens also have their fundamental rights that you need to protect. So when you are going out to execute your mandate as provided by any enabling law, you should also put in consideration the constitutional rights of the citizens that you are meant to even protect. If you are meant to detect, protect, advise on security, it's because of the citizens that you are meant to protect. So when you are going after the citizen, you should put their fundamental rights at heart. You look at their actions, whether they will infringe on the fundamental rights or not. Then, if you see that the security of the nation, which in most circumstances, that's the excuse given by security agencies, outweigh the fundamental right of the individual, most people will understand. But we saw how Emefiele was taken. He was alone at the airport. You saw the actions of the DSS, and in most other cases. But I am not very familiar with their inner workings of the inner workings of the DSS. But I can tell you, they may not need reformation, but orientation of the personnel. I think that's what I would prefer. The personnel need to be given orientation very well in handling issues that deals with the citizens, because you don't trample on the rights of the citizens just based on the fact that you have a mandate that you are executing. No, you have a mandate, but the citizens also have the right they will enjoy. Although, like I explained before, the rights are subject to limitations. But then, when you come at a limitation, the citizens will understand. So they need orientation. I don't think it's reform. The personnel need orientation.
All right, so as we're wrapping up, let's come back to the case involving the DSS and Godwin Emefiele. So right now, the judge has suspended or has pushed, of course, the potential judgment in the human rights enforcement case until July 13th. And we're still in the very early stages. He's being held. And when he was suspended, the statement that came from the office of the Secretary General to the Federation said that he was under investigation for his time at the CBN. What are the next steps that we should be expecting in this case? And it's very likely to be protracted, if I'm correct. What do you think?
Okay, right now, judgment is fixed on the 13th of July. So we are expecting that judgment to be delivered, either admitting Mr. Emefiele to bail or by enforcing his fundamental right, or rejecting the application of Mr. Emefiele. Another angle to it is that then the criminal trial, of course, has not even kickstarted because no charge has been preferred against him formally. So we cannot even talk about the criminal angle because that has not been started. But then the order for his detention, definitely that's going to elapse after 14 days. So I don't know the date they obtained the order, but by the Administration of Criminal Justice Act, the order will last for 14 days. So from today, in fact, before the judgment will be delivered, the order must have lapsed as then. So I think that's another angle they should look at. Before the judgment will be delivered, that order must have lapsed. So we don't know what the judge will say because he has been in detention for, if he's still in detention by then, that would like quite a number of times. I can't guess the exact days offhand right now. But then we should expect either an order admitting him to be and enforcing his fundamental right to personal liberty, although the DSS are free to conduct their investigation if they feel that they have reasonable grounds to proceed against him, and then they can charge him to court based on the advice from the Office of the Attorney General of the Federation. I think this will be an interesting legal battle that all Nigerians are keen and are waiting to see. It should not be like a normal media trial that law enforcement agencies will jump or hop into. Nigerians will be hopeful that something tangible will come out. After so much hope, you will not see anything tangible for like 4 or 5 years. So it shouldn't be like the normal thing we used to see.
Within the ambits of the law, how long can they hold Emefiele for? So let's say that July 13th rolls around and the courts and the judge does give this judgment and says that no, he does not believe that the DSS has in fact infringed on Emefiele's fundamental human rights. And then we're moving along. Again, as we've said, no criminal charges have actually been laid. It's right now what we have to go on are the allegations that the DSS and the Office of the Attorney General of the Federation have made. But within the ambits of the law, you talk about 14 days to be held. There are opportunities for these security agencies to ask for an extension of that. What are we looking at in terms of the timeline and even what the agencies have to work with within the legal structure, within the legal system?
Now, from the legal structure, the DSS have almost expended their days. They've exhausted the constitutional provision of 24 hours and 48 hours. That has gone. They relied on the provisions of the SCJ to get an order from the magistrate court, which is 14 days. So I think they will have one more opportunity to renew or extend the period. I can't guess exactly, but I think it's another 14 days. And once the 14 days elapse, then they must go to court at that time. So I think they have another window, either 14 days. I'm not very sure of the days, but they have another window to extend the period. But after that period, then they will be mandated to take him to court or no other. But if the High Court of the FCT found with Mr. Emefiele and say no, your fundamental right to personal liberty has been breached, or the DSS should release him, there, of course, the DSS will have to apply with the order of court. Of course, I know that's not the court of last resort. You still have the Court of Appeal and the Supreme Court order that they can contend with. But I think constitutionally, those are the period they can still extend the order, but I think it should not be more than 14 days again.
Okay, so Alester Wilcox is on the phone as we start wrapping up the show today. Alester, can you hear me?
Yes, I can hear you.
Fantastic. I'd like to get your thoughts on one or two things before we wrap the show up, and that goes back to the DSS. With the response of Dr. Peter Afunaya, the DSS spokesperson, in an article he wrote, he has said that it's a warped mentality for people to be criticizing the DSS at this point in time, that it's a hatchet job, that it was planted, and that the media editorials that are seeking the reforms of the DSS or have criticized the agency are in the wrong. What do you think of this response in terms of the criticisms towards the agency for its actions and statements in recent times?
The truth of the matter is, we Nigerians are too hasty in criticizing our institutions in doing their job. We keep saying we want strong institutions. Yeah, when institutions do their job, we criticize them. I mean, I don't understand why everybody has become analysts, everybody has become a critic, everybody has become human rights activists, and then that gives impetus to a lot of people to commit crime because the media, the social media, the mainstream media will be awash with criticisms or comments left, right, and center. There was a time when the DSS was such a feared organization. We dare not speak against the DSS. And because they maintain national security, unfortunately, they too has watered down their powers and their influence by dabbling into power, becoming tools in the hands of powers that be. You know, so we are talking about strong institutions. And so each time these institutions will do their job, no matter how big they have most times robbed themselves in the mud, they are still institutions, and we have to protect them. Because that is the only that can keep us together. We talked about security. I'm insecure about the country. Who will do it? You know, the state agencies. And then when they go out to do it, when any big fish is touched, we all raise up. We all rise up and start. Whether put ethnic collaboration, whether put tribal collaboration, whether put religious collaboration to every of their work. So how would they work? So look, we must decide something. Do we want a country that works, or want a country of mediocrity, a country of sentiment? And I said it again. Emefiele's survey did not start with President Bola Ahmed Tinubu. It started with the Buhari administration. Remember, Buhari employed him, appointed him. And it is the same. It was Buhari government that appointed him, that appointed the DSS and the DSS work for the Buhari government. But it is at that time that there was an issue with Emefiele. And then some persons, some cabals, including the Attorney General, was protecting Emefiele. That means there is something seriously fishy. And it is these same people that are protecting it that are instigating, either bringing the tribal angle to it, the ethnic angle to it, the religious angle to it, these same people. So Emefiele must be able to be held down by the DSS and be made to speak on those issues. We need a country that works. We need a country with strong institutions. When they have gone overboard, we know. When they go overboard, when they begin to target things of politics, we know. We can now raise up, press freedom, all those things. When they start to target those ones, we know. But not when people are accused of crime. Serious crime. Crimes that borders of national security. And tomorrow we are shouting at the government, Nigeria is not secure, we want a secure country. Yes, when people that are accused of compromising security is being called to come and answer questions, we raise up in arms, we begin to fight the system. So we must make a difference as Nigerians.
All right.
Do we want a strong institution? Do we want a strong country? You want a country that works, or a country of mediocrity, or a country of sentiment, or a state of sentiment? Then we must make a decision. But as far as I'm concerned, the DSS is not right now with Emefiele, and Emefiele should be made to answer those questions that are posed to him in the law court, and let all those involved come out and defend themselves.
So, Alesta, I'm going to end with you on this. I'll need this answer in just 30 seconds because, Alfred, I'd like to get your thoughts on this. And I'm asking this in light, of course, of we know what's happening at the Presidential Tribunal. A request was made to televise the tribunal proceedings. That request was turned down. There was also a request for the Nnamdi Kanu trial as well, which is still ongoing, to be publicized. That has also been turned down. Do you think that there is a public interest, an overriding public interest in this Emefiele situation that should require this to be a trial that Nigerians have access to, that is public, that is televised? Alesta, 30 seconds.
In the judiciary, even in most countries of the world, you don't televise issues that bother national security. You don't bring in judges. You don't bring in journalists in court on national security issues. Somebody say you want to televise election. Of what value is that? You want to intimidate the judges. Somebody want to televise Nnamdi. Of what value is that? We're talking about national security here. And there are information that this did not go to the public verbatim. Some information are still not classified, will still be classified. And so you are not talking of putting the Emefiele's matter in the open. Come on. Let us work for a country that works.
All right.
For goodness sake.
All right. Thank you so much, Alesta. Alfred, let me hear your thoughts on that. He doesn't seem to think that there's any overriding public interest to have this put out there and televised, that there's national security matters involved and that it should stay behind closed doors. Alfred, do you share this opinion in 30 seconds?
Yeah, now when you talk about televising court proceedings, I'd say we need to look at where we're coming from as a nation in Nigeria. I can remember the case of Mr. Nnamdi Kanu very well. Oftentimes, I've been at the Federal High Court when the case comes up. Now, when the public were even allowed access to the court, most times you see that the place is flooded. People leave what they are doing. They go to court. They just hover around the court. Sometimes they're even beating drums outside the court premises, which definitely will affect the people because the court is supposed to be a very quiet area. So it's a very dicey situation. Yes, the public interest is there, but then the security of the nation is at stake, and the offense for which the person has been charged, and the conduct of the citizens as well. I can assure you, like for the Presidential Election Petition Tribunal, for instance, if you allow the public to even have access or even get into the courtroom, you enter the court and you may not be able to sit down. And when the justices come out, or when the judges, as the case may be, come out, you see the things they say on social media are not pleasant things at all. I am not saying they should be pleased by the public, but the things they say, most people will misrepresent what happens in the courtroom. So I think technologically, we're not even, we're not even up to that. So I think this issue is very dicey. And at the moment, I think I should be of the opinion that they should not be televised. And then the people assessing the premises should be limited, even though I know the proceedings are conducted in public. But I've witnessed firsthand, going to Federal High Court during the trial, Mr. Nnamdi Kanu, I've witnessed firsthand how roads were barricaded. People will come to the court premises beating drums. Why are you beating drums for? I think it's the conduct of the citizens that have led the officials not to accept the application to televise or make public these high-profile cases. I think our attitude as citizens contribute as well.
All right, we'll leave the conversation at that. Thank you so much, Alfred. Thank you so much, Alesta, for joining me this evening.
Thank you. That was my pleasure.
All right, thank you. And the conversations, of course, do not end right here on Politics HQ, where you can find all of the latest information and analysis on the political happenings in Africa's largest democracy. But that's where we're going to end things tonight. Don't forget that you can, of course, join us Monday through Thursday, 7 p.m. West African time for Politics HQ. I'm Tolulakwe Adeleru Balogun. Until next time, have a pleasant evening.